Hello. Madam. Madam, shall I start? Hello. Sharda, madam. Please unmute, madam. Yours. Ah.
You are unmuted. You are on.
Madam, shall we start now? Hello.
1 second. I'll talk
Yeah.
to Scott. You can
Yeah.
start.
Yeah.
Okay. Sir, good morning, sir. Sorry for the trouble. Yeah, we had to make you wait.
Okay, good morning.
Good morning, sir. Good morning.
Mr.
Problem
Dilip
in
coming?
logging in and all.
Yeah,
Can we start now?
from my side. Oh, okay. Hello, Mr. Dilip.
Yes, sir. Also has
Sorry.
logging.
Sir, good morning.
Good
Coming.
morning. Yeah.
Okay, Chauri sir, you start now.
Yeah. Thank you, madam. Let me. Okay. I express sorry to all of you because of technical issue. There was a delay. Respected R. Dilip sir, Navi sir, and other dignitaries and all the participants. A very good morning to all of you. On this pleasant morning, myself, Dr. Dnyaneshwar Chauri, Assistant Professor of K.L.E Society's GK Law College, is pleased to welcome each and every one of you to this inaugural program of 2 days virtual national workshop on cyber security and emerging data protection regulations in India, organized by GK Law College and K.L.E Institute of Technology, Hubballi, in association with our technology partner, Foundation of Data Protection of Professor. PhD in Computer Science and Engineering and MTech in Network and Internet Engineering from Vishweshwarya Technological University, Belgavi. Currently, he is guiding 3 PhD scholars in this area. He also appointed as BOE and BOS at Vishweshwarya Technological University at Belgavi and other autonomous institutes. Here I request Dr. Eriswamy sir to continue the first technical session. Over to you, sir, please. Even I request to Pawan sir to join the meeting. Eriswamy sir, are you there? Hello.
Eriswamy sir, I have unmuted you now.
Madam, can you unmute Pawan sir also, please?
Yeah, I'll do that.
Yeah. Eriswamy sir, please continue this first technical session, sir. Hello. Sir, we are not audible.
Hello.
Yeah. Eriswamy sir.
Am I audible?
Yes, sir. Yes.
So, good morning, everyone. Sir, am I audible now, sir?
Yes, you are audible, sir. You are audible, sir. Please continue, sir.
Sir, warm good morning to all the dignitaries and participants across the nation and from around the world. I'm very much pleased to be part of this workshop, and I sincerely thank our management, K.L.E Society, and the principal and the faculty members of GK Law College, and also the principal of my institution, K.L.E Institute of Technology, for this opportunity to be part of this workshop. We shall start with the first session on the topic Internet Fundamentals, and the lecture is delivered by Dr. Pawan Kumar C, Associate Professor at IIT Dharwad. To introduce him, Dr. Pawan Kumar C is presently working as an assistant professor with the Department of Computer Science and Engineering at Indian Institute of Information Technology, Dharwad, Karnataka. Pawan Kumar C obtained his Bachelor in Computer Science and Engineering from Visvesvaraya Technological University, Karnataka, and Masters in Computer Science and Engineering from Jawaharlal Nehru Technological University, Hyderabad. Prior to this, he worked as a research fellow in the project funded by the Indian Space Research Organization, ISRO. His research interests include coding theory, cryptography, graph theory, and applications. Sir, I request you to deliver the lecture.
Yeah, okay. Thank you for the kind invitation. Hope I'm audible. And also, I would request you to kindly allow me the screen sharing so that I can put on the slides.
Yes, yes. 1 second, please. Sir, you can share now. You are allowed to share.
Hope the screen is visible, I guess.
Yes, yes.
Yeah.
It is visible.
Yeah, good afternoon, everyone. And also, thanks for the kind invitation for this lecture series. And it was a very, informative session in the morning to listen to two great speakers on the topic of cyber security and also the law which is prevailing in the cyber security. Now I'll be taking you through the internet fundamentals, where we will see like what are the fundamentals of the internet, like what are there and how the IP addresses are configured. And to introduce myself, I'm Pawan Kumar. I'm working with the Indian Institute of Information Technology, Dharwad. We are an institute of national importance established by the MHRD, Government of India, and we are situated in Dharwad, and our new campus is shortly going to be live. And also thanks to the information communication technology through which the participants are able to join from all over the country, not only limited to any physical space, thanks to that. And we'll see to that like what are the internet fundamentals. So for this talk, I'll be going through what is the history of the internet, and then internet operations, how it is done, the fundamentals of that, and how do we manage the internet resources, and then policy development process, and how the IP addressing is done and IP routing is done. I'll try to keep the things minimal technically, but I'll make sure that you will understand the concept and how it is been done. So in the beginning, like to start with how the internet started with. So in 1968, there was a need for having a system wherein like you need to share the resources among computers which are present at different buildings. Suppose if you can see the screen over here, there was a like this SRI is the Stanford Research Institute, and then UCSB is the University of California, Santa Barbara, University of California, Los Angeles, and then University of Utah. Like what they did is they wanted to share their resources among themselves. So they created an internet among themselves, intranet, that time it was called as, and it was called as Defense Advanced Research Projects Agency. So they created one network among themselves and created a platform to share the resources among themselves. So the first four nodes we can see here in the network. So this was the first network wherein the internet was originated. Next, moving further, what they did is in 1970, they added one more node to that. And by 1971, there were 15 nodes and 23 hosts connected in the different parts of the country. If you can see the screen, you can identify that how they are connected in the various parts of the country. Sharing this. Right. So in the 1974, the TCP IP model has came into picture 1974 by Vincent Cerf and Bob Kahn, wherein they defined the rules by using which people can communicate over the internet, and it was standardized in 1983 by the called TCP IP model with its 1,000 hosts. Right, and then what is called as a RFC. RFC is called as request for comments. So the request for comments came in by the Internet Engineering Task Force. I think like some of the participants are keen to control the screen and do it. That's fine, but still, like don't say make the people. Wait 1 second. Fine. I think now should not be able to do it. Let's see how it goes. Yeah, fine. The request for comments came into picture wherein the like Internet Engineering Task Force, which is guiding the rules for this internet, whatever the structure is there, they laid out a rule how the systems can be connected. So this RFCs are called as request for comments. So every time the new rules come, like suppose say RFC 1261 in 1991, RFC 1020 in 1987, these are the set of rules which were developed over a period of time, one after the other. So if anyone wants to join this network, they should get a number from the internet so that they can join. And later, what has happened is to make the new users to join into the internet. Like in the initial days when it was introduced, only 256 hosts were possible to connect in the internet. That means it was only possible to connect only 256 members. Later, there is a term called as classes were introduced, wherein there are three different classes were identified as class A, class B, and class C, using which we can address the hosts. Hosts in this uh, nomenclature means that the end devices, like now suppose say we can have our mobile devices as one of the device connecting to the internet with an IP address. So I will explain about that in detail again. Just for timing, just understand that there are the IP addresses called as class A, class B, and class C. If any address that starts with a 0, it was called as a class A, and anything with 10, it was class B, and also class C, it will start with 110. So initially, like what was there in the address space is 50% of the address space was considered like class A, like 128 networks were connected and 16 million hosts were connected, and then in the class B and class C. But the challenge with this was like the address space was started to deplete as the more number of devices started to occupy the internet. That means like day by day we are going on adding more devices to the internet, that is taking the spaces away. So the challenge was to overcome that. Then there was something which was introduced that is called as classless addressing. In the classful addressing, we were having all the class A, class B, and class C. It is now inefficient, and the B space was depleting soon, so they have changed it because, and also there were some issues with the routing as well. Whereas in the classless, what they did is they had something called as net masking. Like you had a higher level IP address, and at the lower level, you can have the subnet masking and connect more number of devices to it, like with some of the criteria like about the least significant bit and the most significant bit. If you can see the address over here, the least significant bit, which means the 0, we can go on adding more number of devices. So using this kind of subnet masking, we were able to generate addresses like 4096 and then 8192 and so on. So if we can give an address wherein 255.255.0 and 0, we could even address 65,536 devices, and it went on increasing by day. So right now, this is one of the classless IP addressing is in picture. Then that is called as classless IP domain register. What is this? Was the one of the standard which was developed in 1993 to overcome two challenges. That is one, the address depletion. That means all the devices were taking up this space very fastly. So they came up with the task called as address depletion. Then so they, to address this, they had developed the classless IP routing, and then the routing table overload. I'll talk about the routing table overload in a while. What does it mean? Then this is the evolution of internet resource management. Like, but the challenge with this classless IP was administrative problems remained as it is, and then to overcome that, some of the RFCs were introduced. These are all the some of the history of the internet, how it came. So to address the challenge globally, what they did is regional internet registrars were developed in the different continents. Like we know there are 7 continents. Like now there are some of them regional open processors and then industry self. So what they did is they divided the area geographically, and for one of the areas they will make it. Like if you take AfriNIC, it will take care of only the internet connections in the African part. In APNIC will take care of the Asia Pacific region of the internet, so on. Like I'll come to this in a detail again. Now, why this internet has become so popular, or what is the challenges involved in it? Like if you see the global users right now on the worldwide scale, we have users such as like Asia is having the highest million number of users compared to the other countries. This data is from 2012, if you can see this. And also how much internet is penetrated all over the things. Like the penetration rate was like in the North America, it was 78% in 2012, and whereas the world average that time was only 34.3%, and Asia was quite low. It was 27.5% at all, right? And then Africa was the lowest that time. But now if you take the recent rates, if you take the recent rates, how the internet usage grown in the Asia since 2000, if you can observe over here, in the internet users in 2000 were only 22 millions in China, and in India it was only 5 million in 2000, and it has now become 462 million. Now you can imagine the growth of internet, how it has been come to. Now imagine an IP address is a number. If you go on allocating a number to each device, suppose say thousands of mobile phones are going on adding every day to the internet. So how do we address all that? So to overcome these challenges, there should be more regulatory policies to adopt all this. So and also there is an argument now that IPv4 is also like slowly depleting all the things, and we are going more slowly moving towards the IPv6. IPv4 is depleting, so we are going to the IPv6. So next question is, how does the internet work? So for the internet to work, there should be a physical connectivity or at least a reachability, which is called as a packet switching, we can call. Whatever the data, whatever is being sent over the internet will be sent in the form of packets. And also like what are the protocols? Protocols are the set of rules which are followed by the devices to communicate. Like now, suppose if you want to travel by a bus or a train, we have certain protocol like take the ticket or reserve the ticket and then do the travel. Similarly, protocols are the same, wherein if you want to travel or send some packets from your device to the another device, you should follow some set of rules. And also this addressing is like finding an address. Suppose say if you want to send some data from your device to another device, then you should have the numbering to do that. So it is called as IPv4. That numbering is called as IPv4, IPv6 and all. But how these numbers are managed? They are managed by regional internet registrars or a higher body, which is IINA, which can be used to regulate this. So I'll also ask a question to the participant right now, like how about the internet? Who controls the internet? Is there a someone individually who will control this IP? That will answer that question. I will answer towards the end. But right now, just try to find out where do IP addresses come from. So IP addresses come from the initially the standard protocols is given by IETF. It is also called as Internet Engineering Task Force. These are the set of standards which has to be followed by everyone to connect to the internet. It is a like a non-profit body which has been set up to control or manage the internet, and that will give the internet assigned numbers authority. What it will do is it will assign the numbers to all the users or all the websites, you can say. And in turn, the regional internet registrars will keep this IP class numbering so that they can manage the number well. And at the local level, ISPs will be there, internet service providers, from which we will get the internet. So if we take our look, like we are the end users, now if we are talking, what we are using is an ISP, that is a service provider like a Geo, BSNL or whoever it is. From them, we are going to a regional internet registrar, like from where we will be routed to what is the global numbers. If you are assigning or if you are accessing some of the servers which are situated outside, then we are using these numbers and we are assigning them. So you can see here, like you are seeing a global routing table as well. Now, suppose say you are in one of the networks, suppose for this network, and if you want to assign or if you want to access something over this net, then what you will connect from this net to this net, from this net and this network, and then this network. So we will get the access from here. So if you want to take some data from here to here, you can take a path from here to here, 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 and here, and it's a bi-directional communication. It's not the single directional communication, as you can see with the double arrow marks, right? So routing is nothing but like routing the packets in the network. So if you are sending a post, so first it will reach the corresponding country, and then it will go to the corresponding state, and then to the corresponding district, and then to the taluk place, and then to the sub post office. Similarly, you can think this a network wherein you are sending a packet from this net to this net, then it will go to this way, this way, this way, and this way. And also you may get a doubt that do we need to follow the same path for this? Absolutely no. You can even take a path from here to here, here to here, here to here, and here to here. So it is a routing protocol, we call it. There are many ways wherein you can reach from source to destination, that is called as routing. But there are more than one ways of doing so. So if you see this internet, like these are the end devices which are connected. They are given by this IP address. So if they want to access some resources, they can do it from any of the computers which are connected to the internet. They can get the data, and also they can share the data. It is similar to our Gmail connection. So if you want to go to see any of the email, then we will be logging on to our Gmail servers by providing the username, and then the by providing the username and the password, and we will access our resources. If you want to upload or download, it will be done with the help of IP addressing. But it is very difficult to remember these IP addresses always, and all these long numbers like 202.12.29.0/24. But there is a mechanism even to control or remember that. I'll just shortly discuss about that as well. So this is how the local routing is done from the global routing. So if you can see this one, like the traffic comes from this IP address to the local routing table. This local routing table will identify the particular device, and the data will be shared with that device, right? So as I told you before, it is very difficult to remember these kind of numbers. So what we will do for that purpose is we will assign a domain name to those numbers. So if you can see here, like suppose there is a apnic.cn is there or .com is there, then what it will do is it will first convert it into an equivalent number which is in this form, and then corresponding location will be looked into. So if you can see this, there is a website by name www.gu.edu.au. Now, if you see the last extension, you can say that whether this is belonging to which country. Earlier, we were very specific about it, but nowadays it has been certainly relaxed. But still, we can make note that .au is Australian domain, .cn is Chinese. All these things you can do that. .com, .org, .net, .co.in, and also like there are something .edu. All these networks are been there. But here, when such kind of an IP address, when we give an website name, it will be processed in the reverse way. What it will do is it will first take the AU and then .edu, then it will go to the GU. We'll see with an example over here. Now I'm searching for a website www.example.edu.cn. Then what it will do is it will first convert it into an equivalent binary format, and then it will check the route where the .cn server is found. First it will find out the .cn server. Once it find out the .cn, then it will find out the .edu.cn. Then it will access the resource example.edu.cn. This is how the example I gave with the country, and then if you give a pin code, what it will do when you send a postcard, first it will go to that particular country, and then it will go to the particular state, and then the district, and then to the taluk, and then to your corresponding post office area, and to the physical location. Similarly, this is also will done in a reverse way. .cn, first it will find the route where is that been hosted, and from then it will see the next server .edu.cn, and then more accurate location is like example.edu.in. Now the previous question which I was asking is who runs this internet? To be frank, no one runs this internet, not the ICANN, not the regional internet registrars, or not the government. It is a decentralized network. But how does it keep on working? It is like a, what to say, a connection we established for better connectivity and business, and also to make the communication simpler. So the engineers and the internet community talk to each other and keep on evolving with this. So basically, no one will control the internet, but only thing is they can come up with a new technology to communicate. Like earlier, we were doing with the 2G. That time, mobile internet was not this much into picture. We were using the GPRS packets. Then came the 3G. Then slowly mobile internet came into picture. Then now 4G. All we are talking about, we are like you can make the difference. SMS are gone away. Wherein only we are using the WhatsApp and also like a communication thing like a Zoom app to communicate among ourselves. So the regional internet registers manage, distribute, and register internet number resources. As I mentioned you earlier, now the numbers will be provided to the end user. Like now I am having a K.L.E website, right? Like now this K.L.E website is situated at some server. But who will give the number to those servers? By an authority that will be maintained by the regional internet registries. So those registries will have a numbering scheme. It is similar to your RTO scheme, wherein like if the people belong to Karnataka starts with KA, if they are from Jammu and Kashmir JK, if they are from Maharashtra MH, similar to that, these regional internet registers will give the corresponding numberings. And there are a total of 5 regional internet registers are there that will be controlling these geographical locations. So what are the goals of this? For the conservation, aggregation, and registration. So if you can see this area, like you can see the color combination also here, APNIC falls in this area of red. So for the entire Asia Pacific region, one of the registries will work, and for the even it will include some portion of the Australia, and also like this LACNIC over this part, and then European by ERIN, and all these will and Russia by Afrinic, and Russian countries, like those things it has been considered. And also if you can geographically map them, you can see this happening in this Asia Pacific region, and this region by LACNIC, and Afrinic by African subcontinent. Those things are there in this case. These are the people who locally give the IP addresses by global standards which are set by the IETF, Engineering Task Force, Internet Engineering Task Force. So this is the structure. If you can see this ICANN, it will give a broader set of rules that is also called as protocols that I will just cover a few minutes later. So that will be having Afrinic, APNIC. Ours is the APNIC, that is Asia Pacific Network. So that in turn will be to the ISPs from where we will get the internet connections to use. So if you are connected from India, now we will be using our ISPs to connect to this APNIC. And if the server is outside India, then we will be using some of these resources from Afrinic, RIN, or LACNIC. So now you can imagine if you want to send some message or an email which is in the other country, then what is the procedure it will take to do that. This is again the structure of the same thing, Asia Pacific Internet Organizations, how this will be done. And also there are some of the chapters like Chennai, Australia, and all. They will be working on some like developing the standards and improving the any best practices they can adopt. And also like the global regulations has been in place to the global policy. uh, 1 minute. Yeah, global policy has been adopted in coordination with NRO by all these registries to keep a balance, because one fellow is giving one address to one system and other will be giving the other thing. So it will be a difficult thing for the joint coordination and collaboration. There will be something called as the NRO. It is a centralized body which will be using this. There will be IP. They will be assigning the numbers based on the regions. Like it is similar to our what do you say, RTO giving numbers to the particular vehicles wherein they can register for this one. So this is the IPv6 address space. So I'll not go much into detail. Like what happens is when in the IPv6, which I giving about the class and other things, we can see there are regional internet registers 130. We can give the addresses, and then there are some of them which are not available. They're only available for the research and other part. We will discuss about it to the little later, but have a idea of this one. What are the part of this IPv4? Similarly, what is there in the IPv6? So if you observe this regional internet registers, each of these regional internet registers are given with some IP addresses they can assign in turn to the devices. So if we are in this Asia Pacific region, and then if you are having some website hosted at this place, then we will be using one of these IP addresses. So if you are in American continent and you are using some of the resources, then you will be using one of these IP addresses, but we don't remember them by their numbers. We will be remembering them by their domain names. Like if you give www.google.com, it will convert into an equivalent number, and that whatever the files are there in that number, that you will be receiving. It's like once you send the postcard to a particular address, whoever is there in that home, they will be receiving your postcard. Similarly, when you send a data packets for a request to a particular service, a particular server, whatever is there in that server will be serviced to you, right? And also, like, there are some policies like aggregation and portability. What does it this aggregation will be doing is, when you are like requesting some of the resources from your device, then there can be aggregation. That means the request can combinedly go to the servers, or they can go without the combination. That is what the aggregation and no aggregation policies will talk in broad sense. But if you go in particular, what they will be doing is, like, they will be like, what are the request and what kind of request it is, and those things can be separated as well based on a VPN connection or a non-VPN connection. That is also possible. So this is the same thing. Like if you see this one, if you aggregate and you can transfer the information, then through the internet you can only communicate with the 4 routes. Whereas if you do with the no aggregation, then you require a 21 routes to talk to each other. So it's a good practice to aggregate and exchange the information than to using the non aggregation policy. But the problem with this is, like, which to combine and not which one not to combine is again an issue here. And also, like, as I told you, that will be done with the help of the routing table. So if you see this routing table, the number of things to route is exponentially increasing over a period of time. So if you see this data, like whatever been projected here, it is of quite old. It is of 2013. But right now, if you take such a data, it will be of huge quantity, more what to say, more larger and more exponentially growing over the period of time. Because in 2013, the internet users were less, and also this mobile phones have not penetrated this much as we have in the 2020, but it is going on increasing. It is also called as dot-com boom. So time, like, the number of users were increasing. Now, how do we move from regional to global policies? While the regional internet registers are responsible for their local areas, how do we globally coordinate them? It is the same thing which I was mentioning. Like, the regional communities will be there, and they will maintain in the regional communities. They will be coordinated with the NRO, and then again some standards it will use, and then all will follow the ICANN name. Now, like, if you want to purchase any domain name or any IP address, so in turn you will communicate with your local registry, and that will do with your higher ups, and then it will finally from the ICANN will assign a number, so that everyone will be equally allocating or equally, what to say, some set of protocol they will follow. Now here we can think, like, two persons are there. If they want to communicate with each other, if they communicate in the same language, then only they can understand. If they are using it with a different language, then there is no use. So now all these people will communicate in a single language, that is the IP numbering. So what they will do is, they will take a domain name and then map it with an IP address, and then give the resources if they are there. Now, a root server deployment, what has been why it has been done is, like, suppose if some of the resources the people in the Indian continent are repeatedly requesting to a given server. So what they can do is, instead of routing all those requests to another continent, you can have a mirror image in the Indian continent and you can use them. So if you are using a latex, or for some reason, you can see that, like, latex is having a mirror server in IMSC Chennai, like it is also there in some of the universities abroad. So we can download it from the local CITAN server which is there in the Institute of Mathematical Sciences Chennai, and you can use those things. So that will be like, you can have the mirror servers based on the requirement as well. Now the IPv6 is the next program which we are looking for, but still it will take some time. Some of the websites are already been providing IPv6 support, but still, like, it has been a quite challenging to migrate from IPv4 to IPv6 and then the deployment. But with the IoT coming up, like wherein we are going on connecting all the possible devices with the internet, then IPv6 will be a reality soon. Now we'll talk about the protocol. Like what is a protocol? It's a set of rules wherein like it will define the communication rules, define the communication process. It defines the structure of pattern for the data being transferred and also information required by the processor in order to order for them to accomplish this. So all data is transmitted in the same way, irrespective of what data refers to, whether it is in clear data or it is in encrypted format. Yeah, this is one of the models which has been adopted for the data communication. It is also called as OSI reference model, wherein like you will have almost 7 layers in this one. What it will do is, now assume that there is an machine sitting over here. It will give the access to the network. So your data will be given as an input to this network layer, application layer. It will present it. That means it will do the translation or encryption or whatever it is, and then it will pass on to the next layer, that is a session layer. And in the transport layer, it will provide the reliable delivery. In this layer, it will be decided how it will be. The packets will be. It will be given how the packet should move, and also we will give what are the header and footer should be there, so that it will provide the reliable delivery. In the network data, we will give the particular IP addresses where the packet should start from and where it should reach. That will be provided by the network layer. And then the link physical layer, that is data for direct delivery by the physical layer. And in the physical delivery layer, it will be done through your physical media, like the data, it can be transmitted through your what is a copper wire or OFC or whatever is done, that will be called as done through a physical layer. Now the another standard is the TCP/IP model, which has been presently used in internet. What they have done is they have aggregated these layers. In the TCP/IP model, what are the tasks of the application layer and the presentation layer are been taken by the application layer itself, and then the session transport layer and network data link layer will be taken by the transport layer, and physical and other 3 layers which are there below this, that will be taken by the internet and network access. So totally there will be 5 layers in the TCP/IP. The remaining one will be a physical layer which is not visible over here, and that will be used to transfer the information. So if you can understand from here that if you want to send some data from your computer to somewhere, then upper layer data, whatever will be there, it will be having some TCP header. This header will have the information where this should go, and also it will have in the transport layer, the thing will be segmented. That means you cannot send the 1 GB data at a stretch, so it will be segmented, or it will be what you say, it will be sliced in packets, and then the packet with some header, it will send to the destination. And also remember that these packets will need not go from a single link to the destination. It will go through multiple links, and again, okay, I will come to that. IP header and MAC header will be set, and through the physical layer, it will be transmitted over the channel. This physical layer can be a copper thing or a OFC, as I mentioned. At the receiving end, whatever the bits has been received will be converted back again with the help of the MAC header layer, IP header layer, and TCP header layer, and finally we'll be getting the data. And also don't think that this process is very simple. It is quite complicated with all the data protection standards, like routing protocols, and also the header protocols, cyclic redundancy checks, and many protocols will be used at each layer to transmit the information to the next layers. So what is an internet protocol? So IP, what we talk about, the IP address, it's an unreliable connectionless delivery protocol. It is like what you say, by using this we will provide what you say, transfer from one device to the another device of the data. So if you can see in general, if you can see the structure of the TCP/IP protocol structure, this is the structure wherein we can use the HTTP or the FTP for file transfer, or Telnet, or whatever the DNS, whatever the protocol we can use. We can use either you can use UDP or TCP, and all these are given in this structure. If you can see that, if you are a computer network student, then you can understand. And also like one more thing is like this structure of encapsulating data and de-encapsulating the data and providing the data from source to destination, even though it is appearing simple, you may amaze that this entire topic will consist of 2 semester course, which you can do with in full length, but still you cannot cover the entire syllabus in 2 semesters. And also there are specializations only relating to this computer networks to transmit the data from source to destination. So now you can understand this better. That means there are some IETF standards are there, then Internet Assignment Numbers Authority is there, then regional internet registries are there. From that ISPs will come, and then we will be getting the end user. So it is like a lengthy process, but when we click on some website, we will be directly going to the content in the website. We will not understand these processes. Now, what are the issues in this IP addressing is the exhaustion of IPv4 addresses is going to exhaust very soon due to the number of devices getting connected to the internet. Suppose say nowadays we are connecting even our mobile phones, our TV, fridge, and everything. They will have some IP address. So this resource is going to deplete very soon. So we are coming with like a new IPv6 standard. That's anyhow a new thing. Now the challenge is here, it is limited availability of the subnets are there. How it is called as limited availability is it will be considered to the 2 power 8 subnets are available. That means 0 to 255 subnets will be there. Total 256 will be available. So one of the things which is there with the IPv4 is this addresses will be in the format of 2 power 4. That means 32 addressing is possible. 32-bit addressing is possible. Whereas if you go to IPv6, it is doubled again. So we are having there 2 power 6 addresses. So 30, you can imagine how much it is not doubled, it is almost 2 power 6 we will be getting. And also another challenge with IPv4 is the routing table length is going on increasing due to the tremendous growth of the internet. So what is the solution for that? One is variable length subnet mask definition, or can we give the hierarchical addressing, classless interdomain routing, and routes summarization. Anyhow, we have seen the classless interdomain routing wherein the classes are not been used, wherein we are using only the classless interdomains for that. And then private address usage and development of IPv6 is the alternative to provide some of the issues in the IPv4. Now in the variable length subnet mask, the challenge is like it will allow the ability to have more than one subnet mask within a network. That means we can even create a sub network to use it. And also some of the things we can use only for the multicast, unicast, and also those kind of features can be used in the this subnetting. And in the addressing hierarchy, what we will have is we will have for the upstream and also like distribution, access. We can have different kind of an architecture for this. You can see here that is this is the upstream, this is the core, and then the distribution switches, and it is the access switches. So like we are having a topology over here. So topology is the arrangement of these core switches and distribution switches and the access points. Like if you are using any access point in your organization, that means the Wi-Fi you are connecting, that means you are doing it through an access point. That access point will be connected to a core or a distribution switch, and this distribution switch will be in turn will be connected to a core switch. So if you are from an academic background, you can see that whatever this border or whatever this switch is there, that is your NKN or Knowledge Network Commission backbone connection will come to. From here, that will be distributed to the other connection. So NKN, if it is giving a connection to here, it will be further distributed to the core switches, and from the core switches to the distribution and the access switches, and from there you will get to the access point. Similarly, for any other connection, if you can imagine a Google, sorry, not a Google, BSNL connection also, they will give a connection to the core, and from core we will be taking the internet connection. So we have seen that what is a classful and classless. So in the classful, we were having the classes for the network boundaries with A, B, and C classes. But in the classless, it has been changed, and we are coming with a classless interdomain routing architecture, wherein we were not bothered about these classes of A, B, and C, and we can use the subnetwork, and we can use more things. And in this is again one of the advantage with the prefix routing. I will not go into detail. And okay. Okay. Now the root summarization is allows the presentation of a series of networks in a single summary address. What are the advantages is faster convergence, reduces the, by using these techniques which I mentioned previously, reduces the size of the routing table and then hiding network changes and isolate topology changes. So this is another autonomous system numbers are globally unique identifiers for the IP network. So this is generally done for the routing purpose as well. So like if you want, you can go in detail. I'll share with this PPT. You can just understand that how this address will be resolved and how you can get the network will work. I'll not go into detail as I'm constrained to the time. Okay, I'll come to this another part. Right, this internet routing I was talking about. So what does a router will do? In a typical router, what it will do is it will find a path and then forward the packet to the next packet. So how long it will keep on forwarding? It will forward as soon as it gets a packet, and it will also find the alternate path and also forward packets. The job is only to route whatever the packages or packets it will receive. So how long it will do? It will route until the power is off. So what is the difference between the routing and the forwarding? See, routing will build the map and give the direction to the user, but forwarding is whatever comes, you forward it to some direction. But here, the routing is done intelligently based on certain parameters like which route is busy, which route is having some space to share more things. That will be computed in the routing table and it will be intelligently forwarded. It's not just forwarding, so it will intelligently do it so as to what do you say, you can manage the traffic. Now, like the IP routing, the path derived from information received from a routing protocol, what it will do is, as I mentioned you previously, there will be several paths may exist in a given network. So how do we send the packages in such case? That will be based on various protocols or a set of rules that is based on the topology, policies, and then what are the metrics been used, what is the hop count, delay, bandwidth. I'll not go into details of all that, but just just understand that there will be many paths to send the data from source to destination. You can choose any one of the paths in this case. These are some of the metrics which can be used for transferring the packets, that is bandwidth, delay, what is the delay in reaching the thing, and load, reliability of it, what is the cost it will be. So these are all, if you go in detail of these networks, then you will understand all this. Now, whenever a packet is or IP address a destination request has been received, then one router will send it to the other one, and that one will in turn find out any request is there for, or any route is found for that particular router, or that resource is found. If it is there, it will forward. If it is not there, it will just drop those things periodically, and it will keep updating the packet. So when you are sending a packet, you can define many things like how long the packet should travel in terms of height and how it should reach. Those things can be done by this. Right, the routing policies are like various routes are there, like it depends on the, it is mainly to done to control the traffic flow in and out of an ISP networks. Again, as I said, there will be many protocols governing the same routing policies. You can see over here that the routing policy from one of the AS1 networks to communicate, if the two networks want to communicate, then what we'll do is AS1 announces the packet flow, and once the AS2 accepts it, then the packet will flow from AS1 to AS2. Similarly, the process will go on. You can see that the packet flow and then the routing flow and how it takes place. Suppose if you see that AS1 must announce to AS2 that there is some packet is there, then if the AS2 accepts, then only you can send the packet to AS2. This is also called as a some sort of a handshaking protocol. That means AS1 will tell to AS2 that we have some packets. Will you accept? Will you be interested to accept? If they say yes, then it will be routed further. So towards the end of the thing, I would like to give these are the things. I will share the PPTs. You can go through. This one will take. Yeah, fine. Now the domain name system is the thing which made in one way this IP addressing popular. What is the DNS thing is? you will be just giving the name of the domain, like suppose www.google.com. It will first search whether the com is there in that or not. It will go to the root and it will first check any com is there. Yes, com is there. Then it will search further whether that thing is there or not. Now, how it will be mapped in a registry? Okay, so I'll just take this example again. Now, gu.edu.au. First, it will check in the GU, and then it will see the edu, and then whether that resource is there. If it is there, it will be sent to that particular domain. But how this will be stored in the name services? There will be some server. This is the same example I wanted to quote. When you use request this resource example.edu.au, first it will search where is AU. Once it is found AU, it will go for edu, and again it will finally locate the resource and give it to you, give it to the user who has requested that one, right? So now there will be something called as resource records.
Pawan Kumar,
Now,
sir,
yeah, tell me.
will you please wind up? We are running out of time.
Yeah, just because I started at 12:15, so another 3 minutes I have, I guess.
Okay, okay. Fine.
Like 45 minutes the duration I was given.
Yeah, please.
Yeah, okay. So like in the records, what you will have is you will be having a label, TTL, class, type, and R data. So when you are purchasing a domain name, suppose say if you take a domain name for K.L.E, it will be having a mapping from the address record that is called as A record. That means K.L.E is mapped to some IP address. So if you the registrar is like accepting the IPv6, then it will be having an IPv6 address mapping also it will do. And how about the name server record is like suppose one of the connection is failing, then how you can map to the other things. And the pointer record will give you where exactly that is fitting place in the servers. And in the mail exchanger and the canonical name, like suppose if you want to give just the K.L.E IT dot it, will it be routed to some address or not? Those things can be given here. So any domain, if you want to register, it will have these kind of records, right? Yeah. When like I'm done with the talk, I have tried to explain with what is possibly with limited technical things, right? Uh, uh,
Yes. Thank you very much, Dr. Pawan sir. It was really a wonderful session. Okay, so I'm audible, sir, Pawan sir?
yeah.
Okay, it was a very, very wonderful session. The session started with a history on the internet, and then the IP addressing, then the internet penetration and usage in India and across the world, then the routing protocols about the organizations who control the internet, and then we also had a very depth technical concepts about the root server deployments and then the autonomous systems. So there are few questions that are asked by our participants. The first one is, one of the participants want to know the difference between TCP and IPv6.
Okay. See, a TCP IP, what you can say is like TCP is a set of rules like which was at the basic level. Over that, you are going to build IPv4 or IPv6. I can share you with some material. You can see that like this V4 at the outset, you can say that it will use the 2 power 4 addressing modes, whereas it will use 2 power 6 addressing modes in IPv6.
Okay. So there is another question which is also related with the security issue.
Yes.
So it is about how can we provide a guarantee of privacy for a GPS-based contact tracing system. So there are few applications what we use. We want to know who is the caller, where he has called from. This is regarding to that application. I think so. And privacy for a GPS-based contact tracing system to ensure public engagement to gather data. So they are asking that when we are talking about such applications, what is the guarantee of privacy in such applications?
No, nowadays, like more than these things, like the problem is all these apps are trying to gather some information about the users. That is the user privacy issue has even Vijay Shankar sir was talking about.
Yes.
Without our consent, everyone is trying to take our data. Like
Correct.
nowadays, few days before, like even WhatsApp was doing that, wherein like the chats were not end-to-end encrypted. Now everything is end-to-end encrypted in WhatsApp. Like that is one way of ensuring the privacy. But when you are using this app, like then we should be very careful, like what it has access to. Now you can see that in the Truecaller, what was happened some time back was like one of the uh, part of the server was hacked. But some people will have the habit of storing their account numbers, credit card details as the contact. So all those things were compromised with the hackers, and they used to get the card details and those things. So it is like a part by part thing. Like certain things the users need to understand, and then they should not do that. But in the other part, like even when you are installing some of the apps, we should make sure that they should not have access to everything. They should have only the limited access. So for example, if you want to if I want to give an example, like why some app which is a like some app, why it should have access to our gallery, right? That means they are trying to have some access from our gallery. Those things have to be taken care of.
Okay, sir. So another question is that cookies, about the cookies. Explain the concept of cookies which pops up.
Hmm.
Is it
The
safe? So it's about
cookies,
the
no.
security. Is it
Okay.
safe?
Cookies are like what is the temporary information which will be stored in the computer based on what has been frequently been accessed. These cookies are nowadays been used to provide advertisements to you. Suppose if you have searched for Ayurvedic products, then you may get some of the Ayurvedic related products recommended to you. So if you have select or searched for some grocery, then you may get an advertisement of GeoMart. So all these things will be done. There are some issues in the privacy as well, which they are trying to like limit the content of these cookies. But no, there is no fully foolproof system. One thing what I can do is just use in the incognito mode, so that like you will not reveal much of your information to the service providers or some of the
Okay.
true cookies.
Okay, sir. Sir, thank you for answering the questions. There are, of course, few more questions are there from the participants, which we will mail it to you.
Yeah, sure.
So thank you very much for this nice session, sir.
Yeah, thank you.
Sir, over to Daneshwar, sir. Sir, Daneshwar, sir, ma'am, or Daneshwar, sir. Hello, Daneshwar, sir.
Sir, thank you, sir. Now we will have another speaker on this on different topic. Already, madam has introduced about the Vijay Shankar Navi, sir. Okay, sir will be speaking about data protection. Data protection and right to privacy. So I request Navi sir to deliver kind of informative lecture on this topic. Sir, please, over to you, sir. Navi sir, hello. Sir, is it audible?
I think I have to unmute him. Just a minute.
Yeah. You're able to hear me now, I suppose?
Yes, sir.
Yes, sir. Yes, sir. Yes, sir.
Thank you. So, morning, of course, it was a general now we have actually planned 3 sessions on the data protection regime. One is what I will be doing now. So, Ranganath was not able to be present, so I will be substituting for him. And then we will be having a session tomorrow by Nagendra on obligations, and then Rajesh on another aspect of compliance. So 3 sessions have been uh, planned, out of which today I will speak more about data protection and the right to privacy in terms of how this has evolved as a law in India over the last few years. Okay, so the Indian position as far as privacy protection is concerned, actually we know that Constitution originally did not make a specific mention of the right to privacy, but we were actually deducing from various Supreme Court decisions that under Article 21 of our Constitution, privacy is being guaranteed in Indian Constitution to the people. Because Article 21 reads, protection of life and personal liberty would not be deprived for any person except according to a procedure established by law. So this was supposed to be interpreted in various Supreme Court decisions to impute the availability of privacy right into this particular uh, say section. What we are seeing is what we call as the Zoom bombing and other things. Somebody is sending arrows here, so let us ignore.
Sir, Navi sir,
Yeah,
somebody is scratching on the screen. You just disable the annotation.
some child must be doing it. One of the participants.
Please disable the annotation
And
in your settings only.
my settings.
Disable annotations.
Actually, it is not in my this thing. It is in some other co-host kind of a person's this thing.
You also can do it, sir. It is not coming here.
In my this thing, annotate is there, but the main host is there. No, I think the main host will have.
Yes, yes, I'll ask him to do it.
You ask him to
Yes, yes, yes.
disable it because I'm not you going to use any annotation myself. Okay.
Yes.
Yeah. So if you look at the legal aspects, way back in, okay, I think some of my, this thing is not, okay, let us continue and enjoy this art. Okay, so way back in 1954, the Supreme Court had an occasion to make a comment on whether privacy has to be imputed into the Indian Constitution. And it was held in this MP Sharma versus Satish Chandra case that at present India does not have a specific provision in the Constitution, and there is no need for a strained construction to import the US concept into the Indian Constitution. So with that, things were going on until, say, the Karak Singh case came and see, if you see both the earlier MP Singh case and Karak Singh case, both are cases where there was a criminal and the police were trying to take some action kind of a thing, and therefore the first one was a case against Dalmia Group. Actually, a district magistrate had issued the warrant also to search, and that was questioned, and whether the police had got this right to search, whether the magistrate has got the right to give a warrant, whether it will affect privacy, was something which was perhaps discussed there. I don't know, at that time the concepts of privacy was perhaps not fully developed. Today when we talk of privacy protection, we talk of protection of privacy of individuals. So that was MP Sharma case. Some of you may go into that details once again, but that is very has very little relevance as of now. Now, Karak Singh case was again the case where police wanted to have some kind of an interrogation or a visit rights to a criminal, and the Supreme Court said that you cannot do that in the particularly in night times. Home should be considered as a kind of a protected abode. So unauthorized intrusion into the person's home is actually a violation of the privacy. This was the concept which was there in Karak Singh case somewhere around the 1960s. In 1990s, again in this Rajgopal case, it was again stated that the right of privacy is implicit in the right to life and liberty guaranteed in Article 21. And some kind of an explanation was also given to the explanation of what is privacy by saying that it is right to be let alone. And this right was supposed to safeguard the privacy of a person, his family, certain intimate information about himself, such as marriage, procreation, motherhood, etc. So these were some of the things which were prevailing at the time when this Rajgopal decision was there. Subsequently, also, a question had come in this 1972 case of Malkani that whether what is the status of a telephonic conversation, whether it is protected under privacy. This discussion still goes on because the Telegraph Act permits the tapping of telephones subject to certain precautions. One of the things the Supreme Court stated in this particular case, which is of interest to us, is that the protection is not for the guilty citizen against the efforts of the police to vindicate the law and prevent corruption of public servants. So here, somehow the judge took the right stand that we should not think too much about all these fundamental rights and other things when it comes to the criminals. In fact, you know that most of the common people in India think that most of these fundamental rights exist only for criminals and terrorists, and a genuine person is never given the same kind of hearing. So this perhaps recognized that kind of sentiment way back in 1972. Then we come to the Puttaswamy judgment, which is the watershed moment in the privacy legislation in India. We call this as Puttaswamy judgment because Justice Puttaswamy was one of the petitioners in this case, challenging the use of Aadhaar as a, let me see whether I can at least cancel all these things. Okay. In the annotation.
Sir,
Yeah.
sir, you need to go there, view options. There is a tab. View options, the drop down you click, sir. Then you should get that annotate there. Yes, sir. Yeah. Please, sir.
Okay, fine. So this Puttaswamy judgment was a case where the Justice Puttaswamy, actually is from Karnataka, he had filed a case against the government for use of Aadhaar and stating that the use of Aadhaar is a violation of privacy. So this went to the Supreme Court, and while the discussion was going on in the first instance, the Attorney General made a statement that we should not worry too much about fundamental rights because privacy is not guaranteed as a fundamental right in India, and he quoted this MP Sharma case. So at that moment, that bench of, I think, 5 judges stopped the hearing and said that we will have to clear this aspect first and we will refer to a larger bench because MP Sharma bench was 8-member bench, so they felt that this 5-member bench holding the hearing of Aadhaar was not having the rights to say disregard this MP Sharma case statement. So then it went to the full bench of 9-member judgment, and then before the then Chief Justice retired, they gave a very detailed judgment on whether privacy is a fundamental right in India. Ultimately, this judgment held that this MP Sharma judgment is overruled. Right to privacy is in fact an intrinsic part of Article 21. It is a fundamental right, but it is subject to the reasonable restrictions which are anyway available in Article 19. 2. So this statement was made by the Supreme Court at that point of time. Yeah, we are having too many technical issues today. Yeah. Now, this particular judgment, therefore, meant that in India, the government, which is the custodian of the fundamental rights, cannot pass any legislation or an act where right to privacy is not properly protected. This was one of the general understandings we take from any of these fundamental rights or constitutional rights issues. But this discussion did not remain to this. Though this basically was meant to be a guidance to the central government that there has to be a due process of law whenever the privacy has to be infringed through any other laws, whether it is Information Technology Act or Telegraph Act, etc. Subsequently, in one of the cases in Kerala, the High Court, which was passing a judgment in Oman Chandi case, made an interesting observation that the newly recognized fundamental right to privacy should be not only used against arbitrary state action, but also it should protect the individuals from the actions of other private citizens, including press or media. So by making a statement like this, an important High Court actually extended that Puttaswamy judgment, which held the privacy as a fundamental right, is also a guidance to the private sector. Okay. But anyway, the government was asked to pass a robust privacy law, and under that assurance, the Aadhaar got its clearance. And since then, the government of India has been working on bringing a legislation. What they did was immediately after the Aadhaar was passed, wherein the government had given an assurance that India will have a robust privacy law, because that was a fundamental foundation on which the particular clearance was given to the use of Aadhaar under certain circumstances. But then they had the Sri Krishna Committee. Sri Krishna Committee gave its report in 2018 along with a copy of a draft bill. It went into the parliament, but parliament term was over. Therefore, a new bill was presented in 2019 December. And that is what we are today discussing as the Personal Data Protection Act. Now, though this Puttaswamy judgment is considered as a landmark judgment on privacy, ultimately, when we look at the final decision, one thing which we see is the judgment did not actually clearly define privacy. The one-page final order, which was signed unanimously by all the people, only said that this MP Singh judgment is overruled. Privacy is a fundamental right. But what is privacy was not contained in the final order. So, if you are a company or if you are a legal professional, ultimately this question of what is privacy still remained even after this particular important judgment. Okay. However, in the individual portions of the judgment, different judges expressed some views which actually to some extent throw some light on what the judges thought privacy was. The definition of privacy, which was in the minds of various judges, was reflected to some extent in the individual portions of the judgment. Of course, Justice Chalmeshwar made a statement that there is no need to resolve all definitional concerns, that is about what is privacy, at the abstract level to understand the nature of the right to privacy. He said it is enough if we say privacy is to be protected, but I will not tell you what is privacy. We will leave it that as a definitional uncertainty. He said definitional uncertainty is no reason not to recognize existence of the right to privacy. So his view was that I will recognize the right to privacy, but if you want to know what is right to privacy on a case-to-case basis, come back to the court, which was of course impractical from the point of view of say business. Say business cannot act without understanding what is the right to privacy. Fortunately, Justice Chandrachud portion of the statement actually gave a sort of a clear definition about the privacy, and he reiterated the old adage that privacy is something which is a feeling of being left alone. So privacy in a simple sense, Justice Chandrachud said, allows each human being to be left alone, and that is something which is inviolable. We need to protect it, and that is what is called the privacy right. He also made a statement that in the current age of information technology, every aspect of the lives of a particular individual is governed by technology. Therefore, whatever we try to do in terms of privacy protection in the physical world, if we don't do it in the interconnected world, which is the digital space, then we will not be doing justice. Therefore, he said privacy should be protected even in the digital world. That is what he said. And therefore, and also he said the dangers posed to liberty in the digital world are something which we need to take special care. Now, having said that, Chandrachud again went further deeper into the definitional aspect, and he also made the statement that the notion of privacy derives from the assumption that all information about a person is a fundamental way his own for him to communicate. So this ownership of personal information is still something which we are debating. In fact, at least some people, including Justice Sri Krishna, in one of the places he made a mention that I would not like to treat the information as if it is a property which is owned by a person. It is not, it's a relationship, he said. That is just like you say, I own a building, I own property. You cannot say, I own the personal information. So he felt that this concept of ownership is not much relevant. In fact, that is why our Personal Data Protection Act uses a completely different kind of relationship definition when it comes to the person whose privacy is being protected and the organization which is collecting the personal data. Internationally, we use two terms called the data subject and data controller. We say that data subject has got certain personal information. He hands it over to the data controller under a certain consent or whatever is the arrangement. And the data controller uses that particular personal information based on the consent which has been handed over to him. That it should be used for such purpose, it should be kept for such period, then it should be done like this. This kind of instructions which are there in the consent. So the relationship is one of a data subject giving instructions to the data controller through a document of consent, which is more like a contractual instruction, where the data subject instructs the data controller to act in a particular way. Now in India, because Justice Sri Krishna took a view that this concept of ownership is not a great idea, he used a terminology which is different, which actually distinguishes Indian law today from any other law like GDPR and puts it a shade above the GDPR, because it says that data subject, we will call him as a data principal, and the data controller, we will call them as a data fiduciary. He used the term fiduciary to define the organization which takes control of the personal data through a consent mechanism and uses it for a certain purpose. Because the word fiduciary is used, we are today looking at this organization. That organization may be a company, it can be a partnership firm, HUF, it can also be a government, it can be a trust, it can be an NGO, it can even be an educational institution. So they are all data fiduciaries who work with the personal data of people, either because they provide any service to them, or sometimes some of the big organizations have employees. Employees' personal data also is part of the privacy protection regime. So this data fiduciary is like a trustee for the data which the data principal hands over. So this concept of data principal and data fiduciary, which is used in Indian Personal Data Protection Bill, which arises out of Mr. Justice Sri Krishna's view that this personal identity information cannot be called something like a ownership data, actually created a completely different system of relationship between the data subject and the data controller. What it meant was that the responsibilities of the data fiduciary were taken to a completely different level of a trustee. It actually gave a certain duty to care in the data fiduciary, so that if the consent mechanism, which is otherwise the fundamental base of all privacy protection, if it is not good enough, it is weak, either I don't have proper definitions there, and we say all consent should be informed consent. That is, the person giving the consent should know exactly what he is signing. In India, we have got language problems, and privacy policies are many times actually written by experienced lawyers. They will use certain terminology which the ordinary man in the street is unable to understand. So when he takes a mobile application or something like that, and before he wants to continue, a screen comes and says, unless you say I accept, I will not allow you to give the service. At that time, the person has got no patience to even read the consent. So presently, the consent regime on which a lot of emphasis is being given, in practice, it is actually a farce. Now, what Indian law has done, therefore, is that while consent we will retain, we want a written kind of an agreement between the data principal and the data fiduciary. Because you are a fiduciary, you are like a trustee, you should know what is good for the data principal. The objective of the act is to protect his privacy. You decide whether you are protecting his privacy or not, whether the consent mechanism is properly worded, whether the person has actually understood it properly, they become secondary. So this actually is creating a duty to care to the data fiduciary. It appears to some extent be a particular thought process which perhaps Justice Chandrachud has not emphasized here, because he has used fundamentally his own. He says it doesn't say it is actually his own, but he says fundamentally in a way it is own, and therefore he should be able to give, use it, or how it can be used in the way he seems correct. So that is what Justice Chandrachud actually mentioned. And he said that there are many situations in which the data, data subjects, the individuals actually will be required to provide the personal information in expectation of some valuable service. So in such a situation, this notion of privacy has to be taken into account. He also made some very interesting observations. He said that data has got three important characteristics. One is it is non-rivalrous. In the sense, we say something is non-rivalrous in the sense that if I have the data and if you want the same data, it is possible. Say in a physical this thing, if I have got a pen and I'm writing, and if you say, please give me your pen, then if I give it to you, then I will not have. So the ownership or possession of the pen is in a way rivalrous. That is either you can have it or I can have it. Data is not like that. I can have it, you can also have it. So that is the nature. Therefore, when we talk of privacy, the information may be with multiple persons at the same time. This is one of the issues to be dealt with. The second is, it is of course not easily visible in the sense that it moves across at lightning speed on the networks. So before you know, your privacy data is with 100 other persons. He also used the terminology called recombinant. What it meant was that data can be aggregated, taken from one source, the output from one source becomes the input for the other source. So these are the characteristics of the data, which we are trying to look at and use it for the protection of privacy. Because of this judgment, in which Chandrachud brought in the relationship between the need for privacy protection in a digital world, we are now today talking of a terminology called information privacy. So what we are trying to protect is, I don't know whether it is protecting the privacy of the individual, but I am trying to protect what is called information privacy. What is information privacy? Information privacy is a terminology which is in a way trying to explain that protection of certain information leading to the protection of the privacy is what is possible, and based on which now we are talking of this data protection law. So information privacy is protecting the information relevant for privacy. Okay, then this is of course this law is under still consideration. In between, even in 2019, a discussion came up in this Ritesh Sinha case, where again it was reiterated that the Puttaswamy judgment considers this as a fundamental right, but it is subject to privacy, to reasonable restrictions. Now, this concept that it is subject to reasonable restrictions, I am emphasizing again and again, because in the process of our discussion with the government today on the modifications required for the data protection bill, which is currently the JPC is meeting experts and trying to understand what needs to be done. There are a lot of other organizations, including supposed to be organizations who know everything about this, like the NASCOM and others. They seem to have a different viewpoint. People like us have a different viewpoint. We have the privacy activists on the one side who say that I want privacy protection irrespective of what else happens in the country. So even if there is a terrorist holding a gun, I don't want to know who is the terrorist. That is because I value privacy to some extent. So you have got one extreme kind of privacy activists who say that privacy has to be protected against any kind of other rights. I'm sure many of the legal professional people hold that view. On the other hand, we have got the technology people doing business. For them, privacy protection law is a hindrance to exploiting the data for business. So they are at the other end and they say, let there not be any privacy protection. Let there be free transfer of personal data. NASCOM says that why should we call financial information sensitive information? Why should we call health information sensitive information? It even goes on to say, why should we call Aadhaar information as sensitive information? Let us drop all this from the definition of sensitive personal information. It also says that let us make it easy for information to be transferred across from India to any other country. So on the one hand, they say that all this critical kind of information like finance, etc., which we know in cybercrime situations, that is what is creating a problem. They say all that should be made non-sensitive, and at the same time, free transfer should be allowed. This is one viewpoint, which is the extreme viewpoint from the industry side. People like us try to balance these two. In fact, I had a recent interaction with the Joint Parliamentary Committee just a couple of days back, in which this came up very strongly that there are people who support privacy at any cost. There are industries who want freedom at any cost. But what we need to understand as techno-legal persons, both the lawyers in this forum and the technology people in this forum, that we need to find a middle path. Definitely privacy is an important fundamental, right? But at the same time, if there is a clash of interest, you have to yield to the other argument. And many people know that we always say that my right to privacy or my right to stretch my hands stops at the nose of my neighbor, kind of a thing. So that is what we have to remember when we study this data protection regulations. So because of this kind of extension of Puttaswamy judgment to the data and the need to regulate the choice of how a personal information has to be used, we now today stand in a situation where this human right concept of privacy comes, the responsibility for that shifts to the IT persons, where the concept is processing of data for a particular business. The two have to find a way to manage this particular dichotomy. Okay. Now, people in the industry, in the information, they have heard of the term called data privacy. Now, basically, in data privacy, we were talking of data as an inanimate object, zeros and ones. What we meant by privacy was maintaining the confidentiality of the data. That was one. We also had a concept called data integrity. Data integrity means the information, if it is altered or modified, there has to be some way of finding it out so that data is reliable for use. If I have got a data, whether it is correct or incorrect should be there. So that is data integrity. Nobody should come in and make some changes. The third concept of information security is making data available for decision making as and when it is required. There is a data, it is meant to be used. If it is not available, we say denial of access. So these three concepts of confidentiality, integrity, and availability, which we consider as CIA principle, this is what the industry is familiar with as the concept of information privacy. But what has happened now is the data protection law says that your objective in data protection, okay, is to protect the privacy of the individual. Now, in order to protect the privacy of the individual, if there is data in the form of information, electronic information, if that has to be protected, definitely CIA principle is relevant. But that CIA principle I am talking of for protecting the personal data, not for the entire data. So CIA principle or the current understanding of information privacy becomes a subset of privacy protection, because the privacy protection will not only have this element of protection of data, it will also have certain other features like obtaining a consent, giving a notice to the person, giving him some rights. These are some of the essential features of the Data Protection Act, which we will elaborate later on. So privacy protection through data protection is a larger thing compared to the information security. That is why we say in industry, if there is a need to protect privacy and you want a privacy officer, or we will call him as a data protection officer, he will have to have some freedom as far as the information is concerned. But what happens in the industry? The industry was until today used to having an information security officer who was protecting not only personal data but also non-personal data. So for him, if he say that personal data, which is a subset of whatever you are managing, will be taken out, I will have a second officer who will be looking at it, but that second officer will be more senior to you, is something which the information security industry is yet to understand. This is the reason why data protection professionals need to be properly guided to ensure harmony within the organization. So I sometimes say that this personal data is like hazardous chemicals. If there is an inventory manager in a manufacturing industry and suddenly the company starts a new production line for which hazardous chemicals are coming in, and the company CEO feels that our current inventory manager is good enough, but this hazardous chemicals inventory should be managed by another expert, and say I will create a second designation for that. This person should not feel that I have been managing all the inventory of this company for several years. Now suddenly you come and say that this particular commodity, I don't know how to handle it. That is the kind of situation we are now having. Personal information, which is a subset of the total information, will be secured by a separate person called data protection officer, and the current information security officer is considered as perhaps not ideally suited. There will be conflict. So this is why I say that a new career opportunity is coming up for data protection officers. Okay. But as I told you in the morning, this being left alone is a state of mind, difficult to know what is the state of mind and difficult to know how to secure it. That is why we ultimately boil down and tell the data principal, I don't know what is your choice. Please tell me what is your choice. I will try to see that your information is managed in that particular manner. That is what we call as exchange of consent. In the industry, most of the time, instead of the data principal coming up and say, I am giving you my data, please process it like this, the request will come from the company saying that I want your personal data, I will give you this kind of a service. So like in the contract, particularly on the internet sometimes, instead of an offer and acceptance, there will be an invitation to offer. The recipient will look at the invitation and then sends offer from his side, and the website gives the acceptance. So similarly, in the case of the privacy, normally a notice is first issued by the company saying that I want your data and this is my offer. And this person will say that I agree and therefore I'm giving you the information. So this exchange of offer and acceptance happens in the form of a notice and a confirmation of that. This is what we call as informed consent. So it is this informed consent through which companies will understand what is the intention of the data principal and then set technical say controls to meet that requirement. But inherently in this process, the right of privacy always has a conflict with the right to information. So privacy versus RTI is one of the conflicts which we have to resolve. Privacy versus security is another issue to be resolved because the government has a legitimate interest. Today morning, Dilip was talking about this, that police are not considered to be persons who are good for privacy because they always are asking for more information. They are putting up face recognition software in CCTV footage, and they know anything and everything about me. When I walk through the street, police will know that I am walking through the street. Okay, but the question is that street is a public place, and if I walk through the street, I am actually interfering with another person's public space. So obviously there is some regulation which has to be there. So police are always coming into conflict with such kind of issues. So privacy versus security is an eternal debate. Privacy versus RTI is another debate. Because of this, we always have to be finding a balance between multiple rights. This is one of the challenges which we have in the privacy area. Now, a question will come that if you say privacy is a fundamental right, what is the nature of the right to security? Should I have a government which does not guarantee me security then why should I have the government? I can live in the olden forest days that might is the right kind of a thing. Today we have elected a government because we expect the government to protect me. Therefore, I am not supposed to take law into my hands. So security is an obligation of the government. It is the duty of the government. And as a citizen, it is my right to demand that the government has the security. Now, is that security as fundamental as privacy? Is something which the people should debate. I personally feel that privacy will come only after the security, because if I don't exist as a citizen, where is the question of my privacy right being guaranteed? Okay, anyway, that is something which some of you may disagree with me, but that is my fundamental way of thinking, that privacy has to find a balance with security. Otherwise, it is not a fair game. Okay. Now, when we talk of this right of choice, and we say that, okay, the data principal will give me some information, and I will manage the information as required, there is one issue which we have to look at. Now, a data principal or any individual knows some information about himself, but it is not that he alone knows everything about himself. Somebody else looking from outside may also know some information about the person. So there is an information which is known to the persons, known to self. If it is also known to the others, we call that as a public information. There is no point in our data protection law trying to protect that, because it is already in the public domain. So public information normally is out of the personal data protection regime. Now, there is something which is known to me, but it is not known to others. That is the data set which is subject to the main personal data protection regulation. Within this, I may say that something is confidential, I don't want to give it to anybody else. Something I have already released to public, and I don't mind releasing it to public again if it is required. But there is another set of personal information which I can share conditionally to the data fiduciary. In fact, all our discussions of Personal Data Protection Act runs around what information can be collected under this conditional sharing. So basically, this is one set of information which the data subject knows and he wants to share it. Now, in the set of information which the data subject does not know, there are some informations which the criminals could have stolen. Okay, I don't know whether it is available, and sometimes they may know more about me than myself. So that is one thing. Now, the Data Protection Act normally doesn't address the criminal aspects. It is left to the laws like Information Technology Act. But anyway, law addresses the issue of stolen information. In India also, ITA 2000 will address it. Personal Data Protection Act will not much address the criminal aspects of data theft, because already there is another law doing that. The second aspect is the surveillance by the government. The government is also watching me, and it is collecting some information. I don't know what is the information which they are collecting. Now, the Personal Data Protection Act recognizes this and tries to put some kind of a limitation on government surveillance. So in a way, that is also part of the Personal Data Protection Act. Similarly, companies do what we call as profiling. Profiling is basically observing your activities and trying to build on that and predict what you are going to do. Okay, that is what we call as profiling. It may be in respect of your purchases you have made on Amazon and other things. It may be your political behavior, whatever is that. So conditional sharing, surveillance by the government, and profiling by a company, these are the things which the personal data protection regulation in any country will try to address. Now, currently, there is this Information Technology Act 2000, amended in 2008. So there is version of 2008 is the central piece of legislation in India which regulates the privacy protection. Of course, guided by the privacy judgment, which is the Puttaswamy judgment. There is also the Indian Telegraph Act on the one side, talking about how privacy can be perhaps infringed in terms of telephone communications. The Aadhaar Act has got its own thing, and RTI Act is there. But central piece of legislation which today regulates privacy in India is Information Technology Act. We should not say that there is no privacy law in India, privacy protection law, data protection law in India, because data protection law exists in India. That exists in the form of Information Technology Act. It exists in the form of Section 43 capital A of Information Technology Act, which says that any body corporate handling sensitive personal information has to follow reasonable security practice. And Section 79, which says intermediaries have to follow due diligence. The term due diligence also is part of Section 43A notifications. There are other additional sections on data retention, Section 67C, powers of the government for surveillance under Section 69. So therefore, there are several things which are already available in Information Technology Act, which cumulatively try to protect the privacy and data protection. Unfortunately, people have not recognized it as such, and therefore we have an issue as if there is no act, the legislation. It will be, of course, continued to be supported by the privacy of ITA 2000 in 2021. So that will continue to be there. Then there is another very interesting legislation which is coming into India, which is called the Non-Personal Data Governance Act. As I was telling in the morning, the moment we identify some data as personal data, it actually has to leave something else which is not personal data. What is not personal data is non-personal data. And since the government has got a separate mechanism to look at the misuse of non-personal data, which is again done by ITA 2000, after taking care of the security of the non-personal data, after taking the security of personal data in the PDPA, the residual part of non-personal data is available for harnessing the economic benefits. So unlocking the benefits in the non-personal data is one of the objectives the government is thinking. And it also, there is a thinking that we need to have something called open data. That is certain data, every citizen should have a right to know, and some kind of data which the government collects should be considered as a sovereign asset of the government, like a natural resource, which the government should have the right to use it in the manner it deems fit. So there is a lot of things which this non-personal data regulation can achieve to add value to the data in general, and that regulation will come. And when it comes, that along with personal data protection and ITA 2000 together will be the legislation which will be governing the data, whether it's personal, non-personal. Today I have put personal data as a bigger circle, ITA 2000 as less. That doesn't indicate what is more important or something like that. It is contextual. Additionally, this Indian Telegraph Act will remain, RTA Act will remain, Aadhaar Act will remain. So the privacy regulatory scenario as it is emerging should be looked at in this whole scenario. I will take questions at the end of the session. Let me complete this. I'm sure there should be a lot of questions. Now, apart from this, there is what we call as sectoral privacy regulations. Some of you who are aware of the global developments, you know that while European Union adopts this GDPR, General Data Protection Regulations, as a regulation to protect all kinds of data, and within that tries to say this is health data, I have to give more value for that protection, financial data, I have to give more value for protection. That is why we have some kind of data which GDPR calls a special category of data. In India, we call it as sensitive personal information. So that kind of data is also part of the regulation. US has adopted a slightly different approach. Basically, historically, it has come like that. They have protected the data through regulations which are sector specific. That is, health industry has got what is called HIPAA, There is a act called GLPA for finance. There will be a separate law for children's online privacy protection. So there may be a separate law for driver's license information. So like that, there will be multiple sectoral laws in USA. So in India, so far we didn't have any specific laws. ITA 2000 was there, and we also said that after Puttaswamy, we have now been drafting a general privacy protection through data protection law, which we call as the PDPB, or which will become PDP 8 2020 if it is passed. In between, there are several sectoral privacy regulations which have come through notifications. For example, if you take the financial sector governed by Reserve Bank of India, which is banking and say payment systems, okay. SEBI, of course, controls one part of the area which relates to stocks, stock trading. Rest of the finance information goes to the Reserve Bank of India. Reserve Bank of India has been having certain regulations which are ideally recognized as information security guidelines. In fact, way back in 1980s, when Reserve Bank of India first permitted banks to use computers, there itself security guidelines for computerization was introduced. Subsequently, when Information Technology Act 2000 was passed, Governor Reserve Bank of India came up with Internet Banking Guidelines of 2001, which had some aspects of law as well as information security. Then when Information Technology Act was revised in 2008 and became effective in 2009, Reserve Bank of India again went into the modification of its information security guidelines for banking and came up with what was called Electronic Banking Security Guidelines under the Gopalakrishna Working Group Committee recommendations, which is like a Bible on how banking information has to be secure. Subsequently, we have what is called Cyber Security Framework in 2016, which has given a lot of information on how the payment systems information has to be secured. But all these things were basically aimed at not necessarily data protection, but cybercrime prevention. So, though for preventing the cyber crime, there was a need to protect the identity of the banking customers. To that extent, it was personal data protection. The regulations never mentioned it like that. It only talked about the prevention of cyber crimes through various measures. Very recently, in 2019, RBI came up with a regulation which is called the data localization regulation for payment systems. That is any financial data emerging out of the payment systems, which is your UPI data, credit card data, and other things. The Reserve Bank today says that that data has to be in India. It cannot go out. In fact, it's a very strict guideline. All the discussions we are having today on personal data protection regulation, where the industry is trying to get it of a free data flow, is not supported by Reserve Bank of India's guideline, which is very strict data localization. So in fact, the Personal Data Protection Act, if it adopts the current version of section 33 and 34, not section 33, 33 and 34, then they will be directly opposing the Reserve Bank of India guideline of data localization. I hope that will not happen. We are expecting that the Joint Parliamentary Committee will perhaps revert the data, which is called restrictions on data transfer. Okay, that's section 33. They may revert it back to the 2018 version, or they may introduce some other means. I hope so. Anyway, okay. So in which case data localization of RBI will have to remain. Otherwise, there has to be some kind of a harmonization of the Data Protection Act and this RBI Act. In USA, many times we get this kind of conflicts between the federal law and the state laws. And there is a general principle there that wherever there is a conflict between the federal law and any other law, whichever is stronger will prevail. So in that sense, suppose the guidelines of RBI is stronger than what the Data Protection Act specifies, probably the regulations of data localization for the financial sector or the banking sector, which RBI manages, should prevail over some of the provisions of relaxed data transfer permissions, which the Personal Data Protection Act may be forced to have in its regulation. So there is, of course, enough provision to incorporate that through the DPA, that is Data Protection Authority's regulations. I hope that will be done like that. When
So still how long it will take, sir?
Pardon?
Still how long it will take?
In your this thing,
Our schedule, it was up to 1:30 only. We are already 2 o'clock.
Oh, we are already at 2 o'clock now.
Yes,
Okay.
yes, yes, sir.
Then perhaps I will wind up in the next 5 minutes. Okay.
Yes, yes,
Whatever
yes.
is left out, we will take it up later. Okay.
Yes.
So apart from financial sector, health sector has got its own regulations through the Ministry of Health. Then a new act was also thought of, but it did not materialize. Government is working on what is called National Health Stack. So health sector, a lot of things are being thought of. Aadhaar has got its own regulations. TRAI has got its own privacy guidelines, which is a comprehensive code which covers everything which is there in the information technology in the Personal Data Protection Act. So that is another sectoral guideline which we have to keep it in mind. Similarly, the insurance sector has got IRDA information security guidelines. So therefore, there are several sectoral guidelines which have to work along with this Personal Data Protection Act. And in future, we will also have certain sections of Information Technology Act which will remain, and that will be the overall canvas with which the whole regulation will be worked out of which, of course, this Non-Personal Data Protection Regulation Act will be one of the most important regulations to watch out. So if you just summarize the privacy protection regime which has emanated from the Puttaswamy judgment, we have currently the Information Technology Act, Section 43A, which is imposing the concept of due diligence, and this concept of due diligence extends to what we are discussing as Personal Data Protection Bill today. And later on, when PDPA comes, that will take over. Different aspects of PDPA will be discussed by my friends tomorrow when we discuss the obligations as well as compliance issues. So that is where I will try to end today's session. I hope we will be able to go deeper into certain other aspects in tomorrow's edition. Okay. So if I have extended it so much, then probably there is no time for questioning.
No, sir. We will have one or two questions.
Okay. Okay. Yeah.
Sir, one question is, what if the privacy of an individual is questioned as part of investigation? The same got leaked, and at last the person was found innocent. Who is ultimately liable for this loss?
The Department of Police have been given certain powers of collecting the personal information without consent, etc., because as a part of law enforcement. But this Personal Data Protection Act does not exempt the police or any other department from security aspects. That is, I allow you to collect it, but this leakage, they have to take the responsibility. So that there is no exemption in Personal Data Protection Act. Therefore, the police also will have to ensure that they will not let this leak out. So if it leaks out, then the person who has suffered a damage can make a complaint and try to recover personal damages. That is one side. Apart from that, the Data Protection Authority may put administrative fines on the department up to 5 crores. Okay, that is what the law says. Okay.
Sir, the second question is, in the light of the right to privacy, what is the problem in making Aadhaar mandatory? Why there is oscillating policy by Government of India?
See, Aadhaar is an instrument through which certain government services are made to reach people. Okay. And that exemption is available in Personal Data Protection Act. Similar exemptions are there in GDPR and other places where national identity, if it is to be used for public good, there is exemption that it can be used. Okay. Again, here, as I told you in the police, security is still the responsibility of the Aadhaar authorities. And also the other departments which provide use Aadhaar. See, most of the time, whatever the Aadhaar related data leaks have been reported so far, they are leaks not from the UIDAI server. Suppose, let us say, your K.L.E college is collecting the Aadhaar of all your 10,000 say students and it is holding in your database, and somebody hacks into that. That is not the responsibility of the Aadhaar authorities. So most of the leakage is like that. Security will still be the obligation of everybody using the Aadhaar information. So that obligation will continue. Failure to that is open to administrative fines. Misuse of that will be covered by the Information Technology Act as a crime.
That's fine. Sir, this is question from my side.
Yeah.
Few of my research scholars, they are working on new technologies like blockchain and spectrums. So what is the present situation of the government about these technologies? Because these are new technologies worldwide. So want to know about it.
No, whatever is the technology, if the technology is used in a particular manner in which the privacy of the individual is breached, obviously it is not acceptable. Now, we talk of artificial intelligence for profiling today and big data. Now, if information is anonymized and used for big data, there is no problem. Okay. Personal data, which is used for profiling by an artificial intelligence algorithm, is definitely within the Personal Data Protection Act. According to Information Technology Act, any automated action of any machine or a software is attributed to the owner of that software. Therefore, the person who owns that AI algorithm is responsible for privacy protection. Now, blockchain is a different concept. So, in the blockchain, people say that I am actually providing privacy by using encrypted identity of a person. So, if that encryption is good enough, then there is no privacy violation. But if encryption is not good, then the same question will arise.
Yeah.
Okay.
Got it, sir. Thank you, sir.
Use of technology. In fact, PDPA even provides for sandbox arrangement. New technology startups can gain 3 years exemption from all privacy regulations and work on technology.
Excellent input, sir. Very nice inputs from you. In the morning, we have also come across 2 of the new technologies you have mentioned. Of course, it has raised some interest, and I also browsed it. One is on the homomorphic encryption. Really a very excellent solution required to the modern world. Sir, in today's session, 2 sessions were discussed. One by Mr. Pawan Kumar on the Internet fundamentals, where we came to know about different things about Internet and the present scenario of the Internet. And from you, sir, Vijay Shankar, sir, it was an amazing, a wonderful session for the engineering graduates like us, because we very seldom talk about the law, about the privacy content. But in the modern classes, we see that students ask these questions to us. Like in IoT, what is my privacy? Or what is my data security? What I should do? Sir, it was an excellent session. I thank you for giving this session, and also Dr. Pawan Kumar for sharing his knowledge. Thank you, and thank for the organizers for giving me an opportunity to moderate these 2 sessions. So over to Dhaneshwar sir.
Thank you, Swami sir.
Thank you, sir.
Thank you very
Thank you.
much. Thank you, Navi sir. One announcement to all the participants. First of all, let me thanks to all the participants for being with us on this platform till the last session of today's. Feedback, because we are getting repeated messages about the feedback, link of feedback. So tomorrow after the completion of all the sessions, during the validatory session, we will be releasing the feedback form. So you have to feel that, okay. So in between we will not be sending. So please take the note of this, and thank you once again to all of you, and see you all tomorrow. See you all tomorrow. Madam, is there any instructions to the participants from your side?
I thank Navi sir specifically, especially and more wholeheartedly, because he has taken a lot of pain to manage 2 sessions today. Apart from keynote address, he has handled one more session also. Of course, he had to prepare overnight. Actually, he is walking encyclopedia regarding this topic, but even then, so at this age, he has taken so much of pain to take this session also. Thank you so much, sir, for enlightening all our participants. And even I was fortunate enough to have your idea of right to privacy, because of course we have studied, we have read Putaswamy judgment, we have interpreted according to our own way, but your interpretation is slightly different what we have interpreted. So your interpretation was quite interesting. We can have further discussions later on. Thank you so much. Thank you, everyone. Thank you so much.
Thank you, all of you.
Meet tomorrow at 10:15.
So we will meet tomorrow at 10:15 sharply. Okay. So you may log in at 10:05.
Thank you.
Thank you, one and all. You may leave now.
Okay.
Yeah.
Yes, bye.